to appreciate what I was submitting to Lordship. What I was submitting not para 16, 17, which I have referred to in the petition. Lordship may kindly permit me to refer to only all another two paragraphs para 16.
You are referring to which paragraph? Para
16, para 16, then you Lordship referred para 17.
16, 17 of the writ petition.
16, 17 and 18. I have already referred to para 17. I will not repeat it here. I will also make kindly see para 16 at page 14. At page 14. Description of the land. That during the revisional survey, the land purchased by the father of the petitioner measuring 3.75 acres comprised with the CS khata number 60, CS plot number 664 of Moja Mangra form part of khata number 210, that is revisional survey. 210, plot number 1421, 1422 and 1422 by 1510. Similarly, the land purchased by the petitioner measuring an area of 6.84 acres comprised within CS khata number 60, CS plot number 664 of Moja Mangra, district Latehar form part of RS khata number 210, RS plot number 1421, 1422 and 1422 by 1510. RS khata number 180, RS plot number 1416 and 1420. So, my lord, khata number, original khata number 60 in CS was divided into two parts. One is RS khata number 210, including the plots in question which they have also stated, and another khata number 180, that is sub part of our original khata CS khata number 60. CS khata number 60 has been carved out into two parts. One is RS khata number 210, another is RS khata number 180. So they claim that they have no concern with khata number 180. They claim the use of the lands appertaining to RS khata number 210. Plot number 1421, 1422, 1422 by 1510. This property, my lord, has been purchased by the petitioner, father of the petitioner, and then another part, that is 3.75 acres and 6.84 acres have been purchased by the petitioner number 1. That those sale deeds are annexed along with the mutation in the year 1983-84 and correction slip I have also brought on that. Now another thing which I will permitted to
Purchased when? Purchased when?
Purchased not in 30th April 1983, Annexer 1. Annexer 1. Other of the petitioner purchased not. I am the sole son. I have stated in the petition also. I have inherited this said property.
So this RS khata number 210 must be mentioned in that sale deed.
That is 60 CS khata. Because RS, yes.
RS khata number
RS khata number
210 must be mentioned in your sale deed.
I am just coming to that. It was during CS khata. Therefore, it is mentioned in this. You also just see for a moment. Annexer 1, page 41. Annexer 1, page 41.
What is the total area of each plot? What is the total area of each plot? Did you buy the entire plot?
No. Your Lordship just similar. That is 75 3 acres. I have just see page 43 in order to reply to the queries. Page 643, part of the sale deed. Description of the land, Sampatti. As you Lordship got it.
Page 43.
Page 43.
A detail of property, Thara number 24.
Yes, that is page 43, not page. That is not 3 एकड़ 75 डिसमिल संपत्ति वार्ड लिखा हुआ हिंदी में 3 एकड़ 75 डिसमिल खाता नंबर 60 दैट इज सीएस का प्लॉट नंबर 665 664. Area is 3.75 acre. And the Lordship will kindly see that so far revisional survey is concerned.
Mr. Sani, इतना हम टैली नहीं कर
ये
सकते।
कहीं कुछ नहीं करना है, अब रिविजनल सर्वे उसके बाद बनी।
देखिए रिविजनल
हमारा खरीदने के
सर्वे
बाद
में क्या कॉरस्पॉन्डिंग प्लॉट नंबर है,
ये हम दे देते हैं
और आपका ये
रिकॉर्ड
भी
में
नहीं-
लाए हैं, रिकॉर्ड में लाए हैं रिविजनल सर्वे।
नहीं, हम टाइटल सूट यहाँ नहीं डिसाइड कर सकते।
टाइटल शूट नहीं करना है, मेरा एक ही मेरे कहना है कि ये 83 में परचेज है, मेरा परचेज है पिटिशन नंबर 1 का, मेरा पिताजी का 83 में था, मेरा परचेज है जो हम रजिस्टर्ड सेल डीड लाए हैं तो 3/1/1985, दैट इज एनेक्सर 4 पेज 56।
आप पिताजी से परचेज किए हैं?
नहीं, हम दूसरा प्रॉपर्टी दूसरा पार्ट खरीदे दूसरे से, जो लोग ओरिजिनल ओनर थे।
चौहद्दी क्या है? चौहद्दी में क्या सेम प्लॉट है,
चौहद्दी
डिफरेंट प्लॉट है?
डिफरेंट प्लॉट सेम है, चौहद्दी अलग अलग, हम देखते थे।
तो फिर how do we earmark? When you say that you are in possession of plot number such and such, you do not say कि
चौहद्दी-
what is the boundary of that
Yes,
plot
page
number by
43,
which
page
page 43 से नहीं देखी
अब पेज 43 तो बाउंड्री है।
boundary.
Page
You see, it is not your case that the entire plot has been purchased by you. You purchase a portion of the plot.
Yes.
So where do we get the boundary in your writ petition? Show me that it is bounded by such and such area.
Yes, that is the
Then how do we know?
sale deed shows about the boundary.
Sale deed
Lordship
से
may kindly see, I have just referred page 43 for that purpose. For that purpose only, your Lordship just see boundary is there, चौहद्दी, उत्तर में उत्तर पश्चिम पूरब सब लिखा हुआ।
आप बताइए, पढ़िए जरा कौन सा प्लॉट नंबर लिखा है?
प्लॉट नंबर 664 का हम जो खरीदे हैं, उत्तर पूरब में जगामोची, दक्षिण में पूरा।
प्लॉट नंबर नहीं लिखा है ना मिस्टर सानी?
प्लॉट नंबर तो नहीं
कैसे पता चलेगा? You just tell us. When it is not your case that you have purchased the entire plot number, then how do we determine that this entire plot number का कितना एरिया है, क्या बाउंड्री है, वो जो बाउंड्री में जो है वो कौन सा प्लॉट नंबर है? How do we know that?
प्लॉट नंबर खाता नंबर तो आया है सेल डीड में, और जो रिविजनल सर्वे का जो है पेज नंबर 67 देखा जाए, एनेक्सर 6 जो रिवाइज हो, सर्वे खतियान जब रिवीजन हुआ उसका जो आया है, उसकी जो का क्वेश्चन
कोरेस्पॉन्डिंग प्लॉट नंबर
हाँ,
पढ़ा होगा ना?
दिया
ये तो कोरेस्पॉन्डिंग प्लॉट नंबर में पूरा प्लॉट नंबर में से कौन सा पोर्शन का कितना प्लॉट नंबर कैसे पड़ा, ये सारा
ये
चीजें
हम-
रिट पिटीशन में कैसे डिसाइड करें?
रिविजनल अथॉरिटी ने खुद लिखा है।
Does the revisional authority say that this entire
Yes.
property,
That
this entire plot number, कौन सा है plot number? 1421 entire, 1421, 1422, 1422
कितना
slash
हम खरीदे हैं वो आया है
entire area,
पेज 67
entire plot number.
एंटायर प्लॉट नंबर आया है, उसमें दिया हुआ है।
This is the last document I am seeing from you. इससे ज़्यादा हम
3 documents I have
नहीं,
shown
बस और बताइए कौन कौन सा 3 document?
Annexer 6
6.
page 67. This is the regional survey record of right prepared under section 83 of this Chotnagpur Tenancy Act and in the year 1995. Lordship just see Chotnagpur Kaskari Adhiniyam as a Lordship got it.
Page 67.
67.
दिखाइए property
Annexer 6
details and
दे
चौहद्दी.
रहे हैं। बाद संख्या 482-89 के आदेश अनुसार हाल खेसरा 1421 के दक्षिण से ली गई रकबा 1 एकड़ 43 डिसमिल, 1422 के दक्षिण पश्चिम से रकबा 2 एकड़ 34 डिसमिल, 1510 2 एकड़ 32 का खाता वादी मोहम्मद सिद्दीकी फादर ऑफ द पिटिशनर मोहम्मद सिद्दीकी सचन सच के वाकयात के नाम से दर्ज समझा जाए। So it has been recorded in the
How?
record of
The
right.
entire
Your Lordship is
plot is
correct.
not in your possession. It is not your case
But
that your
I
entire
am not
plot
claiming
is.
entire land.
Then
I am
how do we
claiming,
determine
I
आपका
am
कौन सा
claiming
portion
the
है?
land which I have purchased and which is recorded
How?
in my
Who
name.
will determine it? Inch tape लेके कौन नापने जाएगा वहाँ?
That is the deputy commissioner is to
Deputy
see.
commissioner, so go and file a suit.
Deputy commissioner cannot decide this.
Deputy
But when
commissioner
there is
also will not go with inch
and
tape.
now your
Right.
Lordship may kindly see the when the record of right has become final under
भाई
section
आपका ये सब जितना प्रिंसिपल है ना, ये तब अप्लाई करता है when the entire plot would have been in your favor. You
Entire-
have only portion of plot numbers.
I am claiming my writ petition I have confined to my land which I have purchased.
So
In
your
1980
land, the identification of your land which you have purchased on the spot, who will determine that?
That is the reason why this honorable court directed them to speak out what portion they have constructed and what has not been. That is the reason the order was passed.
That's
So Lordship may kindly see and page 68 में मेरा नाम से है petition number 1. That is also division
आप
of that.
बताइए, आप बस
एक चीज और बस ज्यादा नहीं बोलेंगे बहुत ज्यादा नहीं. So Lordship may kindly see for a moment that mutation orders are have also brought on record. There is no dispute about it. Another thing, Lord, which I was submitting for Lordship, if the plots have been mentioned in CS record of right as Garmajurwa class, and that is the basis of their claim that it is Garmajurwa class, so therefore it is belongs to the state, and therefore the state is the owner. This is the contention embodied in the counter verdict. For that purpose, this judgment I beg to place reliance upon. Admittedly, I am paying rent since 1983 till 2024. Admittedly, my father was paying rent while he was alive and in respect of the property purchased by my father. In both the properties, I am paying rent. Mutation order has been issued. Correction slip has been issued, acknowledging my possession with issuance of rent and the correction slip by mutation, and that has not yet been challenged or cancelled. Now, therefore, after remaining more than 30 years, more than 60 years, now 50 years, they say that it is since it is recorded in the CS record of right as Garmajurwa Khas land, therefore it land belongs to state. For this purpose, this judgment, the Lordship may kindly look into. And I will place only 2 paragraphs of that judgment, which I have already produced to you. So Lordship just see. Presumption on the part of paragraph 9, 10 and 11. Presumption on the part of Halka Karmachari that land in question is a Garmajurwa land is not permissible in the eyes of. If state government is claiming ownership upon property in question, which is in possession of original petitioner, which is in possession of the predecessor in title since 9/6/1942, civil suit is the only remedy available with the state of Jharkhand. They cannot drag the citizens to be plaintiff. Burden of proof lies upon the plaintiff. Burden of proof that the state is owner of the property in question lies upon the state government. Defendant has to deny allegation. There is a vast difference between burden of proof for the plaintiff and for defendant. More than 30 years old entries and documents cannot be upset by or cannot be brushed aside by one line report of Karamchari that land in question is a Garmajurwa money. What my submission for Lordship is that in the counter affidavit they have boldly stated that it is since it is recorded in the CS record of right as Garmajurwa Khas land, therefore the land belongs to the state. That is my submission. Admittedly, I have brought on record registered sale deed, I have brought on record correction slip, I have brought on record the rent receipt, and since 1983, continuous possession over the property in question, and still without taking recourse to law by acquisition under the Acquisition Act, they have used it. Now, my lord, my submission to Lordship, Lord, before approaching this honorable court, I have approached Lord the Deputy Commissioner, that is annexes 16, 17 and 17A. Those remained pending, and therefore I had to approach this honorable court. Then your Lordship may kindly see the judgment which I have already placed before your Lordship, only 2 paragraphs. The Honorable Supreme Court, what has been held, I will not take much more time. The Lordship just see the unreported case Vidya Devi, which I have already referred to. I will not read you. Para 10.6.
You have read it. Why do you need to read it again?
Yeah.
ये तो आप प्लेस कर चुके हैं.
नहीं, उसको पढ़े नहीं.
पढ़ लिया
आप पढ़े. 10.4 से उसे पढ़ा जाएगा, हम नहीं पढ़ना चाहते. The contention of the state that the appellant or her predecessor had already consented into the acquisition is completely baseless. We find complete lack of authority and legal sanction in compulsory divesting the appellant of her property by the state. In a democratic polity governed by the rule of law, the state would not have deprived the citizen of their property without the sanction of such and such. This court in the case of such and such, we are surprised by the plea taken by the state before the High Court that since it has been in continuous possession of the land for 42 years, it would tantamount to adverse possession.
They are not claiming adverse possession.
They are saying that we are the owner. On the
They are
other
not
hand,
claiming adverse possession. Are you? Is there a case of adverse possession?
they say they are the owner. And
So
that
they
is
are-
the reason
so
that
adverse possession का paragraph किस पे
वो छोड़ दो delay approaching ultimately my lordship में कहानी सी paragraph 11 the honorable Supreme Court took into consideration the appellant has been divested of her right to property without being paid any compensation whatsoever for ever half a century. The cause of action in the present case is a continuing one since the appellant was compulsorily expropriated of her property in 1967. The present case is one where the demand of justice is so compelling since the state has admitted that the land was taken over without initiating acquisition procedure or any procedure known to law. We exercise our such and such.
नहीं सर आधा मत पढ़िए पूरा ही पढ़िए
हाँ पूरा पढ़ा.
हाँ
We
142
exercise
में
our extraordinary हुजूर का पावर है
हमको पावर नहीं है ये 142 में पावर एक्सरसाइज
डायरेक्ट स्टेट टू पे कंपेंसेशन उसके बाद हुजूर
142 में हम पावर नहीं एक्सरसाइज
ठीक है.
कर सकते ठीक है
142 में पावर नहीं बाकी तो लॉ लेट डाउन हुआ
ठीक है, law laid down हुआ।
लॉ लेट डाउन हुआ. दूसरा जो जजमेंट हम दिए हैं एक और जजमेंट हुजूर को दिए हैं इस ऑनरेबल कोर्ट का उसमें लॉर्डशिप जस्टिस forcibly and illegally demolish and bulldoze the building premises उस पॉइंट पर आया था जो डीसी अपना मन से किए थे उसका अल्टीमेटली पैरा 5 में the honorable court has been pleased to take pen off referring to so many judgments and ultimately
what was there on the spot when this school has been constructed
nothing
it was a vacant land
it was vacant land but it has been they have used it as if own without taking into consideration my objections supported
में आप सिविल कोर्ट में जाके इंजंक्शन मांगते हैं ना तो आपका अभी तक ये कहानी कब तक डिसाइड हो जाएगा इंजंक्शन का कहानी
उसको तो हम
226 में ही आपको
आज तो चले गए वहाँ. अब इसीलिए मेरा कहना है कि जजमेंट देके कि स्टेट गवर्नमेंट जो खुद अपने आप को मालिक मान रहे हैं उसके लिए उनको सिविल सूट में जाना चाहिए था डिक्लेरेशन के लिए. हम कहाँ मना कर रहे हैं कि आप जमीन मत लीजिए.
आपको इंजंक्शन में नहीं जाना चाहिए था सिविल कोर्ट में
हमको पब्लिक
हाई कोर्ट से इंजंक्शन
पब्लिक पर्पस के लिए हम इंजंक्शन हम तो मांग नहीं सकते हैं मांगे भी नहीं. हम
मांगे अब
स्टेट
तो यू आर ऑलरेडी डिस्पोजेस्ड
नहीं स्टेट तो था ही इंटरिम स्टेट जो हुजूर देखे हैं हुजूर उसके बाद ये लोग सब मांगे भी
कंस्ट्रक्शन ऑन वेकेंट लैंड
construction on vacant land. But that vacant land belongs to me. Your lordship is correct in saying that who will decide whether it belongs to me or whether it belongs to the state. The state says in their counter without supporting document. On the other hand, I have brought on record the document of the statutory authorities. My humble submission is that I should get compensation for the lands which they have used. This is my submission.
आपको क्या बोलना है
Yes, Your Worship. Referring to the counter to Your Worship, para 8, which we have, I have referred it in the earlier round, Your Worship. Where in Annexure A we have enclosed, Your Worship, the land record, Your Worship.
which counter
First, Worship, dated 10/12/21.
Land record register 2 have.
सर आपको नहीं डिस्टर्ब किया ना आप यस
वो explain करो.
इलेक्शन ए
Yes, this is the detail, Your Worship. From right side, your खाता का प्रकार गैर मजरूआ खास, which is admittedly a government land. खाता number is the
Admittedly नहीं ऐसा
सर अब नहीं सर बोल नहीं आप कर लीजिए सर हम रुक जाएंगे वेट सर
गैर मौजूदा खास इज गवर्नमेंट लैंड
गवर्नमेंट yes your worship and now you should refer to page just turn on page 31 the khata number you want it is 210 your lordship 6 and 7, column 1 from left, your worship, plot number 1421, 1422.
Is 1421, 1422.
Yes, your worship. The third column, your worship.
One
पुरानी पड़ती गैर आवाज काबिज हुई. It was a vacant land, so there is no question of disposing the petitioner. And if we calculate the total area, 3 acre, 98 decimal, 12 acre, 28 decimal, altogether the 15 which we are using, and this is our categorical statement in all three affidavits, your worship, that we have not neither disturbed the petitioner nor touched his plot. This is entirely, and this is the record of right is the basis of ownership of any of the person or even the government, your worship, if it is not written. And in this only, your worship, if see 1422/1510, wherein 2 acre 32 decimal, wherein in the remark column it is mentioned that Avaid Dakal Mobi Bhuya Pita Kasa Bhuya. So if there is any ownership or any encroachment or anything is there, there is nothing written in the remark column regarding this plot, your worship, upon which the the school has been constructed. Then, your worship, I am referring to page 6, para 9 of the same counter, your worship, wherein public notice was issued regarding construction.
Yes.
Yes, That is stated in submission that the authorities have followed the due process of law to acquire the said Gair Majarua land of RS Khata number 210, plot number 1421 and 1422, and plot number 1510. Published the public notice proceedings has been started, and letter of communication between the authorities for acceptance and direction to start the construction work. The inspection report and escape map was also given to the as per the report of the Amin, that is annexure B to the counter affidavit, your worship. Then I will refer to some more paragraph, your worship. Para 18, I will take, your worship, page 14. Here comes, your worship, the nature of the transfer of land, which we claim that as per CNT, even that transfer is invalid, your worship.
You
That
just
we
come
have-
to the map where the construction is taking place. This is the map, page 42.
Yes, your worship.
This is 1420 भी एक तरफ है, एक
Yes,
1423 भी है,
1424.
and this is
And this is
1424. And where are they located?
Your worship, that map is not there, but we have said on oath, your worship, in counter supplementary counter, that we are not concerned with this petition. All the and even I will just refer to the supplementary counter affidavit, your lordship, dated 9/12/2022, your lordship, wherein this petitioner, all the petitioners were physically present when upon the direction physical verification was done. 9 December 2022, supplementary counter affidavit, your lordship.
What happened on physical verification?
Yes, your lordship. I will page 3, paragraph 5 onwards, your lordship. It is stated in submitted respondent number 7 has issued notice to the petitioners, while letter number so and so dated 24/9/22 to appear before the respondent number 7 on 27/9/22, along with all relevant document of the said. It is submitted that during the inspection, it was found that the building construction of Eklavya Ashram School, Magra, Badwadi block is almost complete. The plaster work and the wiring work has also been completed to the school. It is stated and submitted during the inspection, along with petitioner number 1. It has also been found that construction work is going on land of Khata number 210, which has been transferred to the contractor for construction of Eklavya School by the competent authority. So this petitioner number 1 and all the petitioner were asked and physical verification was done. Inspection was there, Your Lordship. And in next paragraph only, at para 8, Your Lordship, we have stated that neither the land of Khata number 180 has been transferred to the contractor for construction of Eklavya Model School, nor any construction work is going on the land of Khata number 180, which has been mentioned by the petitioner in IA number earlier IA of 207520, which they claim that we have encroached upon that, Your Lordship. So our categorical statement in that we are constructing on the as per the records of right the land which belong to government. Your Lordship. We have nothing whether he has purchased or not, and as per CNT Act, we are in our counteractive category disputing that even that is not permissible, even though it has been done, because now it is on record, Your Lordship. As per CNT Act, OBC cannot transfer to SC, SC cannot transfer to OBC. So basically, we are challenging even that transfer. But so far, construction of school is concerned, we are not disputing that whosoever is in possession of plot Khata number 180. We are only concerned with Khata number 210. And now school is ready, and just because of this pendency, that is not being handed over. It is complete.
Heard the learned comes
One
from the
thing,
findings.
I'll just take a couple
This
of minutes
petition
here.
has been filed for the
If you may see the counter bill, their counter bill, which they have filed. You may just see page number of the same counter bill. Page number 42, the map, you also just see. And then page 45 and 46. They have annexed. This is the registered to. Registered to in the name of father of the petitioner. They have annexed. I have also annexed the correction slip and all these things. Then we will page 42, that is their document. After the map road to page 45 and 46. Page 45 relates to, you also just see the Sarak Siddiqui, Muhammad Siddiqui, in the name of father of the petitioner, and this is in respect of the land already given by Sikh, Khata number 60664, 3.75 acres, which is the purchase by the father of the. The next document is annexed D by 1, page 46. Right
I
mutation
can't read these documents.
310 by 8586 in the name of the petitioner number 1.
I
Next,
can't just read his documents.
they have produced, and it is readable, which I have find from the entry made there. My learned friend cannot deny this.
इसके
This is
नीचे
the
पढ़िए।
entry in the name of ऊपर में होगी, बीच में.
ऐसे पार्ट में कोई डॉक्यूमेंट थोड़ी पढ़ते हैं, क्या लिखा है क्या नहीं लिखा है, हाउ डू वी नो?
तो पार्ट नहीं, तो उन लोग लगाए हैं नेक्स्ट रजिस्टर 2 का फोटोकॉपी ये लोग लगाए हैं, जो रजिस्टर 2 मेंटेन हुआ है 1983 से, जब से हम परचेज किए हैं. बाएं तरफ जो देखा जाए खाता नंबर 60. अच्छा, एक और डॉक्यूमेंट जो ये एनेक्सर ए दिखाए हैं उसको जो एक सेकंड देखा जाए. ये जो डॉक्यूमेंट देंगे सब वैलिड है. व्हाट इज दिस, whether it is a record of right. I have shown to your lordship the record of right, page 67, page 68, and a certified copy. And this is not record of right. Annexer A. What is truncated document? Typed it and produced before this one. Whether this can be relied upon? No signature, nothing, no authenticity. I have stated in my rejoinder also. Whatever they have produced before this one report, and they have produced my document also, registered to, showing my possession since 1983. And apart from this, so far plot number 1422 by 1510, Abad Dakhal Farmer, they are the vendors of the petitioner. And we have registered, certificate, we have annexed, the lordship just can tell you the name of those persons. They were in possession, they transferred it to me in 1983 and 85 respectively. They said that we are not concerned.
Heard the learned counsel appearing on behalf of the parties, this petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner slash the father of the petitioner are the owners of entire 10.59 acres comprised within RS Khata number 210 and RS Khata number 180 pertaining to RS plot number 1421, 1422, 1422 slash दो बार होगा ना 1421, 1422
oblique
comma
151.
1422 slash 1510 comma 1416 and 1420 and were in exclusive possession of the property. The grievance of the petitioner is that the Deputy Commissioner Latehar had recommended for transfer of land in Khata number 210 of Circle Barwadi, Village Mangra 24, Mangra /24, bearing plot number 1421, 1422, 1510, area 3.98, 8.78, 2.32 respectively, total being 15.08 for the purposes of construction of a school. The learned counsel submits that the land belongs to the petitioner, though it is vacant land, but they were throughout in possession of the property by virtue of registered sale deed executed in their favor, and the petitioners have been paying rent on the same. The learned counsel has submitted that the respondent state ought to have acquired the land before starting any construction, but no such acquisition of land has been done. And as of now, the construction of the building is complete. The learned counsel submits that if the state was claiming title over the property, they ought to have filed a suit for declaration of their right, title, interest and possession. But the manner in which the Deputy Commissioner has acted for the purposes of giving the property of the petitioners to construct a school building cannot be justified in law. The learned counsel has relied upon the judgment passed by Honorable Supreme Court in the case of Vidya Devi versus State of Himachal Pradesh, civil appeal number 60-61 of 2020. It decided on 21/2008 to submit that the state would not have violated the right of the petitioners to hold the property involved in the proceedings. He has further submitted that the Honorable Supreme Court in the state case had directed for payment of compensation with regard to the property. The learned counsel has further relied upon the judgment passed by division bench reported in 2018 with bracket 1 bracket 2 JVCJ 584 HC para 9, 10 and 11 to submit that the state cannot forcibly take possession of the property and asks the person agreed to file a suit. Rather, it would have been proper if the state would have filed the suit. This court has considered that the fact that in such circumstances the burden of proof would be on the state to establish right, title, interest and possession. He has also relied upon the judgment judgment passed in WPC number 2628 of 2011 decided on 27/6/2024 and has referred to paragraph number 5 and 6, wherein the houses were sought to be demolished without taking recourse to provision of law. And such action has been deprecated by this court. The Learned Counsel has also submitted that the building having been constructed, the petitioners would be satisfied if compensation is provided to them in lieu of the land which has been utilized for the purposes of construction of building. The Learned Counsel appearing on behalf of the state has opposed the prayer and has submitted that the state in the counter affidavit has asserted that the property on which the building has been constructed belongs to the state. He has also submitted that admittedly the property was vacant land and it is not a case where the state has demolished any structure and dispossessed the petitioners to take possession of the same. He has submitted that as per the counter affidavit, the record of right as maintained electronically
Yes.
in a digital mode. Digital mode?
Yes, this is web copy only also. You get it in the
Web copy of the record of rights have been annexed, showing that the property involved in the present case is Gair Majurba Khas, and the description of the property involved in the present case has also been mentioned. The Learned Counsel submits that upon spot inspection by virtue of orders passed by this court, the map for the construction has also been annexed along with the counter. He has submitted that there is serious dispute with regard to right, title, interest and possession of the property involved in the present case, and in case of vacant land it is all the more difficult to determine the possession. And therefore such disputed facts may not be decided by this court. After hearing the Learned Counsels appearing on behalf of the parties, it appears that in Circle Barwadi, village / Thana number Mangra / 24, Khata number 210, plot number 421.1422.1510, area 3.98, 8.78, 2.32, total 15.08 acre was allocated for the purposes of construction of a school building. Admittedly, the property was vacant land. The petitioner as well as the state are claiming right, title, interest and possession in connection with the property. The petitioners are relying upon registered sale deed followed by rent receipt in connection with the which have been annexed along with the petition to submit that the property belongs to the petitioner. On the other hand, the state is
And revised Khatiyan also.
and on the other hand, the state is relying upon the digitized record as contained in Annexure A to the counter affidavit, showing that the property has been shown as mentioned as Gad Majurba Khas, and according to them, Gad Majurba Khas means government land. They have also submitted that this court finds that in the case of vacant land, this court finds that it is not a case where the houses have been demolished and the petitioners has been dispossessed. Rather, it is a case where on a vacant land some construction of the school building has been made. In case of vacant land, it is all the more difficult to determine the possession of one or the other person. This court finds that there are serious disputes with regard to right, title, interest and possession with respect to the property involved, and accordingly, and as of now the school building has already been constructed. In such circumstances, the dispute involved in the present case cannot be decided in writ jurisdiction. So far as the judgment passed by Honorable Supreme Court in the case of Vidya Devi Supra is concerned, it was not in dispute that the property involved in the said case belonged to Vidya Devi. And it is apparent from the said judgment that pursuant to certain orders passed by the concerned High Court, the state had initiated acquisition proceedings under Land Acquisition Act with respect to the persons who had objected and by the writ petitioners. And the case of Vidya Devi stood on similar footing, but she had not filed a separate writ petition. In such circumstances, the Honorable Supreme Court considered the admitted facts on record and by exercising power under Article 136 and 142 of the Constitution of India, directed the state to pay compensation to the appellant, within bracket, Vidya Devi. It was an undisputed fact on record in the same case that her private property, that she was deprived of her private property by the state without resorting to procedure prescribed by law. In view of the title dispute involved in the present case, the state judgment does not help the petitioner in any manner. So far as the judgment passed in WPC number 2628 of 2011 decided on 27/6/24 is concerned, the grievance of the petitioners in the state case was that the authorities were trying to forcibly and illegally demolish the building premises in which the petitioners were, which were situated on the royalty land of the petitioners, without following any procedure of law. The state judgment also does not apply to the facts of this case, as admittedly the structure which has been built up involved in the present case is on a vacant land, which was initially a vacant land. So far as the judgment passed in case reported in bracket 2018 bracket 1 bracket close JBCJ 584 HC is concerned, the entire case of the state was based on the report of the Halka Karamchari, who gave a report who presumed that the land in question was Gair Majuba Malik land. Such a course was not permissible, was held to be not permissible. In the said case, the property was in possession of the original petitioners and their predecessors in title right from 9/6/1942, and this court held that the civil suit is only remedy and the state cannot drag the citizens to file civil suit. And in such circumstances, if the state claims to be the owner of the property, the state should file civil suit. The state judgment also in the present case, the petitioners are claiming to be in possession of the property since 1985, since 82-85. And the present case is not based on any report of the circle officer or Halka Karamchari. Rather, the state is relying upon the land records maintained by the state to claim that the property involved is Gair Majuba Khas. Considering the totality of facts and circumstances, this court may, in view of the aforesaid facts and circumstances, the judgment relied upon by the petitioner does not help the petitioner in any manner, as there are serious disputes with regard to right, title, interest and possession. It is sufficient to observe that the aggrieved parties shall be at liberty to get their right, title, interest, possession, etc. declared to a competent court of civil jurisdiction. Any observation made in this order will not prejudice either parties. This petition is accordingly disposed of.
वो ठीक से चल रहा था, इतना मोटा पाइप कैरी करना है उसको।
नहीं, एक चीज और लिख दीजिए. It is, there cannot be any doubt that if the title is ultimately found to be in favor of the petitioners, then it will certainly be for the, it will still be open for the state to take appropriate steps for the purposes of acquisition of land. ऊपर लिखेंगे है ना?
From supplementary list case item 19, the local 4579 of 2021.
Site appears to the sea.
No problem. No problem.
So in this case, basically the documents. It's a case of threats of pure penalty, which was taken.
Your voice is breaking, Mr. Sanya.
The Installation Act 96 issue at the head. Yes, I was.
I can't see you. I can't hear you.
Speaking. She can hear me. Now, can you hear me now? Can you hear me now? I think
Yes, I can hear you. You can just.
now you can hear me.
No. No. I can't hear you.
Now you can hear me.
The voice is breaking. The voice is breaking, and therefore it is difficult to comprehend what you are.
इनका म्यूट हो जाएगा.
Earlier also you had joined online and the voice was breaking, therefore the case was adjourned. It is muted at your end.
It's not muted at mine.
We are not able to hear you.
Set it up. Why is it? Yes, leaderships now.
The voice is breaking.
Hear me now.
The voice is breaking, we can't hear you. You have not even filed your synopsis, have you?
File it. It's fine. It is a small case, in fact, of the workers who have been fighting since a long time. And in fact, we went to the Honorable Supreme Court because the court was closed during COVID. In the last page, all you should have a kind
Your
of
voice is breaking.
What is file functioning? You should probably go to that. My voice is breaking. Probably some connection problem maybe, but for my right, that's I can't any disturbance on my side. Probably some internet connection could be process, and basically what we are saying is that parties are governed by the order of.
I can't hear you.
chairman of BCC.
We can't hear you. Your voice is
Settlement
breaking,
the right time.
and your
For
the
not
screen
giving
is
effect
freezing.
to the-
The screen is freezing. We really can't hear you. The voice is breaking.
So can it be on another day, issues?
Will you come down? Will you come and argue?
Or if waiting for a day, that's a long time. Like,
Will you
that's why
come and
some-
argue?
Maybe some other. the
Which
client-
day? Which day will suit you? Tell us.
Sir, give me another chance over BC. One more chance.
Over BC.
Any day, any day. Any day, 2:30 any day.
Just tell me one thing. You are seeking basically enforcement of settlement of 1972.
Every-
How many persons are still willing to pursue this case?
But we were one of the mine which was taken over by government, BCCL, and there was
No, how many
basically
persons are still aggrieved and how many persons are still alive? How many persons are involved in this case?
the prosecution will
166.
continue.
Sorry?
Thereafter,
166
166 persons.
of 72.
166 persons are involved in this case.
Why would we delay? We can talk, be a workman. Be a workman.
So certainly, I want to know, are these 166 persons still alive? Those who claim to be working as back as in the year 1972. You are talking about a settlement of 1972.
The side would say this, that it's an old settlement.
No, we do
But
not.
that is the
See,
risk.
I just want to know from
There is
you,
not many.
how many persons are still interested in this? How many persons are, stakes of how many persons are involved in this? You are representing the workmen, right? There are altogether 166 workmen as per 1972 settlement. And this is your case. I want to know that how many persons are still interested.
That is it.
Can you provide us the list of persons who are alive with their Aadhaar card?
Some of them are still
Some of them, many
there. So
of
many
them.
are there, still there. Still
We
there.
do not know who all are there. Give us the list who all are still alive. And they are still in a position that they will work in the company.
Provide a list.
Yes, and as it is, you see, settlement of 1972, kindly appreciate settlement of 1972. Firstly, how many people must be alive so
That's a
far?
hard reality.
That's a hard
That's a hard
reality,
reality.
yes,
That's a hard
certainly.
reality.
But we will not pass a judgment in a case which is absolutely useless. I must, at least I want to know that how many persons are still interested in this.
We'll find a list. We'll find a list.
With Aadhaar card, not a list.
There is no list even in the entire petition. Not a name.
We'll find a list.
Where is the name where is the list of persons in the writ petition and where is the list of persons in the settlement? Is there any list attached to the settlement?
But the settlement is not there.
Attached here.
Where just a moment, where is the list? Let me just have a look at the list.
There is no settlement also.
And where is the settlement of 1972? It must have annexed it. Yes, where is that settlement? Where is it in the writ petition? Where is that?
Yes, yes,
Annex 2 in the supplementary agreement.
Yes.
Annexure 2 in the supplementary.
supplementary affidavit. Refers to a list. Annexure 2 supplementary affidavit. Annexure 2 supplementary affidavit. Should be at the top. And the list is referred to.
Where is the list? Where is the list? Terms of settlement?
Yes, yes.
Where is the list of persons? It's not there.
item 3 is published enclosed herewith. Item 3, and terms of settlement, item 3, the management agrees to employ the workers enrolled as per list enclosed herewith as per provisions of the IDI.
So now let us see one thing. This particular settlement, which was arrived as back as in the year 1972. Now, can this settlement be enforced? Can it be enforced?
I mean,
There are two reasons. Many of them might not be surviving. And secondly, 100% of them must have attained the age of superannuation. Correct? Therefore, under such circumstances, is it not a futile exercise to decide this case? Who are the persons to whom we can give any relief? Tell us.
can I? Many of the persons have disappeared, that is true.
No, not only, you see, 100% of them, 100% of them must have attained the age of superannuation. You calculate the age, how many years have elapsed? Since 1972? Then, it's an infructuous writ petition. We are absolutely with the workmen. Our most sympathy with them. But 1972 settlement, can you insist on its enforcement in 2024? And even if some of them might be existing, it will be a huge issue identifying them. Just tell us, how many years have elapsed since 1972? Kitna?
28 और 24
हाँ.
52
years.
That's right.
So, this case is infructuous in all respects. Absolutely infructuous. Just tell us what relief can I grant? And it is a settlement for the purposes of re-employment. It is not a settlement for the purposes of any compensation. No.
We've been trying, why would we wait? We never wait. I mean, we wanted to enforce it. Some reasons, some orders.
So we do not know what happened. From 1972, this settlement remained unenforced. And if you still have some grievance, you may have some compensation. We do not know. Whosoever was at fault will be taken care of. We do not know. We cannot decide who was at fault, why this particular settlement, the so-called settlement, was not implemented. But we can't grant you relief. What relief are you seeking from this court? Just tell us, let us see your relief. I spent some time with the record to find out what is happening since 1972.
72 is a stage when coal mines were not even nationalized. They got nationalized
You see, it is irrespective of the fact whether they acknowledge this settlement or they do not acknowledge this settlement. Even if they acknowledge this settlement, the workers involved stand nowhere. It's an infructuous case. If you still want to come, you come.
They went for conciliation failed. They did not get the matter referred for adjudication to the tribunal. Half a dozen writ petitions filed before this court.
It is absolutely, especially it's an infructuous case. We can't grant you any relief. Should I decide it right away?
Supreme Court. The last order is
That's right. Supreme Court has said. Supreme Court has not asked us to decide an infructuous case. It is now we have to. That's right. The Supreme Court will not non-suit you. Supreme Court did not entertain the writ petition, saying that you may have your remedy before the High Court. As simple as that. But when we see the relief that can at best be granted to you, to the workmen, is reinstatement. And 50 years have already elapsed, and all of them.
Bad luck.
Certainly, it's a very bad luck. We do not appreciate this kind of delay procedure and legitimate rights of the people to be defeated. But it is staring at us This record is staring at us. What relief can I grant? It will be absolutely futile exercise. We do not issue futile writs. We are not here to issue futile writs. There was a settlement for reappointment, and it cannot be disputed that none of them can be reappointed. Not even one of them can be reappointed as on date, even if we pass such an order. Tell us, you want us to pass futile writ orders?
Well, can we allow some of them can, because none of it is their fault.
That's right, but we cannot pass an order on compensation, can we? Can we decide who is at fault?
Then the custodian of the license plate, this is item 164 in the list. Custodian also directed us to rush senior counsel report to stop prosecution against chairman and
We
the
do not
secretary,
know
but
what will ultimately happen. We are not concerned with the prosecution. We don't need to bother about it. That is not even the relief prayed for in the petition. That they should be prosecuted. There is no such relief.
started the BCCL very high court indicated in the ground we have indicated that at least the prosecution can go on. Obviously,
We do not know what will happen to the prosecution. We are not concerned with the prosecution in this case at all.
and then suddenly Mr. Justice Iqbal's or only 151. Page 187. 187 page. One 187 and at 201. The order of this honorable court. 201. Last paragraph. Last paragraph, you should have a look at last paragraph 201. Obviously, leaderships have seen this order. Line. Yes, just Seva Iqbal accident was so far improved so far. Is concerned, I do not find a reason beyond possible for the implementation of settlement and award is still the same. So it is held assisted.
That was just at the stage of show cause. Section 29 notices were issued to them. The court did not find it appropriate to quash that show cause notice.
That means but against others members of this show cause was called, but it continued. Suddenly they dropped it. We do not know why it was dropped, how documents were missed.
We do not know. We are not concerned. You see, if some proceeding has been initiated,
kind of allegation against if that can be allowed to how did it disappear after this what happened to that order? This order attained finality.
yes, we do not know what happened. You should have pursued it. You should have pursued it.
Already hasn't that
Where do you say that the section 29 show cause after having been after the court has refused to interfere, the matter has not taken to a logical end, has not been taken to a logical end.
this order after this order
And I'm sure by this time even that section 29 notice must have become infructuous. Because section 29 notice is issued against individual persons by name. Isn't it? Yes, Mr. Mehta?
Yes.
Yes, he must have also retired by now. You see, section 29 notices are issued against particular persons by name, because authority by itself, the managing director of a company by
I'm
itself.
saying it's a continuing.
It could be a continuing wrong, but as on date, no relief can be granted to you.
No prosecution, but the rest
Even-
will continue. For the rest, because
No. No relief can be granted to you. After expiry of so many years.
the section 29, that is my subject to continue.
If there is any proceeding pending under section 29, that will be taken to a logical end. We don't bother about it. Why should we bother about it? Because the proceeding under section 29 is not under challenge. I will observe that only. If there is any pending proceeding, that will be taken to a logical end. This order will not be an impediment to that. It can't be an impediment to that. We do not know.
Can a exemption be given by you?
That should be sufficient, Mr. Mehta. If there is any proceeding, that will be taken to a logical
Yes,
end. We are not here to decide that matter.
Had there been
But so far as your main mandamus is concerned, we can't grant you any relief.
Right.
That should be
I will
sufficient.
give you obliged if that.
I will make that observation. Don't worry about it. Thank you. Writ petition L number 457.
More people will benefit from that.
We'll see that. You just listen to the order, and if you are finding it difficult to listen from here, you can join the YouTube. YouTube में connection मिलेगा हमको? आपको मेरी आवाज सुनाई दे रही है? Can you hear me?
Pura.
Okay. All right.
Pura.
All right. Then kindly listen to the order. WPL number 4579 of 2021. Heard Mr. Subrato Sanyan, learned counsel, appearing on behalf of the petitioner through online mode. And MS Abha Kumari, Abha Verma, who is present in the court. Heard Mr. A.K. Mehta, learned counsel, appearing on behalf of the respondents.
numbers 3 to 6,
Respondent number 3 to 6.
number 7 to 10.
Heard Mr. Ravi Prakash, learned counsel, appearing on behalf of respondent number 7 to
10.
10.
And 1 and 2. 1 and 2 and 7.
1 and 2 and 7 to 10. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the respondent, Regional Labour Commissioner, Central Dhanbad, and the authorities under him have refused to recognize a settlement dated 16/3/1972, which was entered into between the workmen and the management of colliery and have refused to refer the dispute for adjudication. Correct, Mr. Mehta? By the impugned order dated 9/12/2020.
That's it.
The learned counsel submits that the settlement has been annexed as Annexure 2, which has been filed along with supplementary affidavit dated 15/5/2023. And as per the settlement, the management had agreed to re-employ the workers as per the list enclosed after the reopening of the collieries.
Sir, this employer is the ex-colliery owner, not the present. Pure Benidi colliery
Okay.
was
The learned
nationalized on
counsel submits that the settlement dated 16th of March 1972 was with the then colliery owner, and the settlement is binding on the respondent BCCL, who are successor in interest.
Under whom the mine has vested by operation of law.
Under whom the mines have vested by the operation of law.
Namely, Coal Mines Nationalization Act 1973.
लिख के दीजिए please. During the course of argument, it could not be disputed by the learned counsel for the petitioner that the settlement by which number of workmen were to be re-employed and was dating as back as on and was entered as back as on 16/3/1972. All of them either might have attained the age of superannuation, or they might not be alive. The learned counsel is not aware about the present status of the workmen involved in the settlement. Upon a further query, the list of workmen does not find place in the writ records. At this, the learned counsel for the petitioner has referred to the judgment passed by this court in WPC number 1296 of 2002, dated 19/2/2002, and has submitted that when the settlement was not being enforced, notices were issued under section 29 of the Industrial Disputes Act for launching prosecution.
The section.
For launching prosecution under section 29 of the Industrial Disputes Act, and this court refused to interfere with those notices. He submits that he is not aware as to what ultimately happened to the show cause notices. He has also submitted that once the show cause notices were issued, the same was required to be taken to a logical end when this court had refused to interfere with the show cause notices. That is sufficient? Is that okay? Mr. Sanyal,
One push can well.
these are your submissions?
Case.
Sorry. These are your submissions, right? The learned counsel appearing on behalf of the respondents while opposing the prayer has submitted that there were altogether 166 workmen involved, and there can be no doubt that they might have either attained the age of superannuation or would have or may not be alive.
After 52 years.
After 52 years from
Of this date.
16/3/1972, he has also submitted that the workmen claimed that they were already working in the colliery and they were to be re-employed, meaning thereby that they were already in employment for some period of time. The learned counsel has further submitted that as per the impugned order, the government, the Regional Labour Commissioner Central, has refused to refer the dispute for adjudication. यही है ना?
ये
Reference.
actually refusal जो है, they have refused to. Yes, it is also there.
Yes.
वो मैं दिखा देता हूँ.
And the conciliation
Has failed.
has failed.
Yes.
After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court is of the view that the petitioner is seeking to enforce the so-called settlement dated 16/3/1972 by and between the workmen and the management of the then colliery. The present respondent is successor in interest by virtue of the aforesaid Act of Coal Mines Nationalization Act 1973.
Kindly see one page, Manoj. Page 242. I'll just read, that is the order of the government. Page 242.
Yes.
In quotation, when an ID was raised with regards to non-implementation, what the government of India says is the claims of workers of Pure Benidi Colliery Private Limited for re-employment by Messrs.
The
BCC.
Learned Council has also, ऊपर ही लिखे हुए, the Learned Council for the respondent has also relied upon the order dated 29/1/2014 passed by Government of India, Ministry of Labour, wherein the claim for re-employment was held to be a belated claim,
As more than 40 years.
as more than 40 years had passed from the date of nationalization of the labor.
Kindly see the next page, Bello. One paragraph, the first paragraph, and to refer to the email so and so.
That should be sufficient.
That, yes.
उसके बाद finding it. In view of the aforesaid facts and circumstances, this court is of the considered view that the impugned order dated 19/12/2020 does not call for any interference and is further of the view that no relief in terms of the settlement, so-called settlement dated 16/3/1972 can be granted to one or the other workman. However, in case any prosecution has been initiated under Section 29 of the Industrial Disputes Act as submitted by the counsel for the petitioner, the final outcome of the same has not been brought on record, but if it is still pending, the same is required to be taken to a logical end. This petition is disposed of with their proceed observation. That's all. The act can now.
In time frame,
We can't. We do not know what is happening there. We can't give any. We just that should be.
From daily list item 15, the rupees is 655 of 2021.
This petition. Yes, petitioner.
There are two demands which we have challenged, Annexure 5 and Annexure 7. By Annexure 5, a demand of rupees 2 crores and odd was demanded, and by Annexure 7, that was enhanced to rupees 5 crore. So before placing those, Your Lordship,
You have no arbitration.
no.
Where is the respondent? Hindustan Petroleum. Where is the agreement?
Your Lordship may only see because there is no arbitration.
Yes, the agreement. Where is the agreement? This
That
all
is-
this petroleum
it is there
companies
in-
have
Only for
arbitration.
1 year, but not in 2015 to 16. That expired in 2016.
The period has expired, but your demand is existing,
Yes, demand because they are in position.
still in possession.
They are still in position.
Yes,
they are
yes,
running
absolutely.
petrol pump and suppressed also, my lord.
Under whose which brand of petrol they are selling?
Indian oil.
Indian Oils. This is
SPC,
Hindustan
sorry,
Petroleum.
Hindustan Petroleum.
No, I don't get it. The relationship is still continuing.
My lord,
Yes,
in
yes.
fact, my lord, the lease which was given to them, my lord, so far as the running of the petrol pump is concerned, that was continuing since 1953. In 2015, again, it was an agreement was entered, which was for a period of 1 year only. And after 2016, there is no extension, but he is in position over the land itself, and he is continuing.
And you are supplying Oil must
I am not supplying. I am railway.
They are railways,
Oh, you are
their land,
railways.
we are.
I am
we are
railways. My
licensees.
land. My
I
land
was
is
just
the.
wondering.
No. Well, they are the Hindustan Petroleum, to whom not
Eastern is Hindustan.
Hindustan
Oh,
Petroleum.
I thought that. हाँ,
With the-
बताइए।
Your Lordship में
क्यों
allow me
लड़
to
रहे हैं
place
आप
and
लोग?
then
दोनों जने गवर्नमेंट क्यों लड़ रहे हैं बताइए
अब लड़ रहे हैं
क्यों
इसी
आप
के
लड़
लिए
रहे
तो
हैं
डिमांड है
इमिटेशन करिए आप लोग ये सब फालतू बात मत करिए क्या है ये क्या कर रहे हैं कोई किसने डिमांड रेज कर दिया
railway.
रेलवे
किस
रेलवे
चीज़ का
अगेंस्ट
demand?
एचपीसी है
जो land which is acquired by them, in fact, in possession of them, for which the petrol pump was being run, the land rent that has been the demand notice has been issued to them only for that.
आप इनको tenants
And I have also asked, we have also
you are
given a
treating them
notice.
as tenant
Yes,
why need to throw them out
Lord, we have given a notice for vacating that has been stayed by this honorable
so
since 21. In 2021, that no coercive steps shall be taken. Well, Lord, we have given a notice for vacating, so for
एक
other.
बात बताइए जो लैंड आप एक्वायर करते हैं उस पर आप कुछ रेंट रियलाइज कर सकते हैं
हाँ मेरे सर्कुलर है.
that anybody who is in occupation after post
Anybody knows
acquisition.
the commercial use, my lord, so far as that part is concerned, there are policy. On the basis of policy, only the land was given. Now we are in the need of Amrit Bharat scheme is to be implemented in Dhanbad, for which we need the land. But now for that purpose only we have filed an interlocutory application.
What
for
was
vacating.
the period of lease?
In fact, my lord, previously it was coming out, so far as the pleadings are concerned. In the year 2015, there was another agreement for the 1 year, and after expiry of the period,
Between railways and
HPCL.
HPC.
Yes.
Okay.
That after expiry of the period, they have not paid any rent, and it has continued. It appears, my lord, that they both are the public sector and the state Union of India organization, and therefore probably the matter has not been taken care of, my lord, and it was continued. The liability has been. The matter is with respect to the fact when the demand notice was given on the basis of the subsequent policy decision with respect to the realization of rent. Thereupon, my lord, the matter has been challenged. Subsequently, my lord,
Your grievance is the demand or you want to continue?
both
Both.
demand also
Very good.
and therefore your Lordship may
No,
allow me to
the-
place
Just
my
look
case and
at
then
it. उनका केस सुन
हाँ,
रहे हैं।
हम एक फैक्ट खाली हम
Interesting
ऐड
है।
कर दे रहे हैं. Lease was given to HPCL. There was a specific condition in the agreement that it will not be subletted. They have subletted it to
बात
another.
ये यहाँ टेनेंसी एग्रीमेंट हम लोग नहीं ना डिटरमाइन करेंगे
नहीं तो यहाँ तो हम लोग आए हुए हैं, उसी चीज के लिए हम भी बोल रहे हैं.
आप भी जाइए
एक बार देखा तो जाए जो लेटर हम कौशिक के लिए बोल रहे हैं that in that only a demand of rupees 2 crore and what has been claimed
Only.
and then subsequently
Reached to
they
5
say
crores.
5 crore and then they say because you have not paid 5 crore therefore you vacate. Now all these that it is needed for personal requirement and all those were not there on the ground. The ground is that you have not paid 5 crore. So therefore, before I have to only establish that the demand raised of rupees 2 crore and subsequently 5 crore, I have come for quashing of those.
आपको 2 करोड़ देना है कि 5 करोड़
नहीं कुछ भी नहीं
कुछ
वो
भी नहीं
उतना नहीं देना इसी के
तो
लिए हम
कितना देना है
एक एक बार हम बता रहे हैं
नहीं,
थोड़ा
पहले
सा
बताइए कितना
एकदम
देना है।
एकदम क्लियर है एकदम क्लियर है योर लॉर्डशिप में one by one 3 to 4 annexures of their own document your lordship may see absolute clear calculation is there absolute
Where
clear.
is the lease deed?
Pardon?
Where is the lease deed?
That is in our counter.
Before that your lordship may allow me to place 2-3 documents I'll show that also
Where is the lease deed? पहले आपका lease deed है।
लीज डीड नहीं है वो लाइसेंस है
हाँ।
annexure 3 at page 35 this was the last license that was renewed
First one कहाँ है?
but first it is running since 1953 time to time the lease license fee was enhanced
This land belongs to railways since 1953.
yes and the HPCL is there since 1953 itself from time to time it was enhanced and license fee is continuously paid by HPCL I would have come to annexure 3 before that 2 annexures I just wanted to show
because that would clarify entire matter.
Milord, may I say one thing, Milord? They have not come out with a specific statement, Milord, with respect to the fact that the land which had given to them, Milord, that has been subletted to another dealer itself.
He is the
Milord,
dealer
those
of
facts have been
HPCL.
suppressed, Milord. And since when he is continuing there, Milord, that is to be explained, Milord, so far as the petitioner is concerned.
HPCL cannot run the petrol pump itself. It has to
That
run through.
agreement which you have
through
written
the
on
dealer
that basis.
itself. It
There
runs
are
through
so
the
many.
You have
dealer.
your
There are
company
so
owned
many.
also.
Yes, company used to run.
You
It
have
is
company owned dealership
Yes, yes,
also.
but it is run through a particular
No,
person.
But that
who
is
has
not
to
the
run.
agreement. That is not the agreement.
But Your Lordship, here, Your Lordship, therefore, before Annexure 3, I just wanted to place two other documents and then I'll come to Annexure 5 and 7,
You
which are.
place your case.
Yes, yes.
You just
Yeah.
place your case in your
Yes.
own manner.
One by one annexure, Your Lordship may see annexure 1.
Apparently, on the
I'll
face
show
of
you.
it, your action doesn't appear to be bona fide, so you will place your case with your bona fides.
Ye-
also.
Yes, yes, absolutely. Your Lordship may see first the first annexure. This is annexure 1, page 30. Your Lordship may see.
Okay. Annexure 1.
Yes. Subject is outstanding dues towards the license fee of railways land measuring 8,000 square feet as at Station Road, Dhanbad. So here there are two plots and 3,500 square feet. Katrasgarh, this is not concerned. We are concerned only with 8,000 square feet, which is at Dhanbad. And the first one is outstanding dues and area measuring 8,000 from 2011 to 2005 is rupees so and so. Total amount is 1,32,640. This is the amount which was calculated between 2011 to 2015, 4 years, and the total amount was 1,32,640. Therefore, till 2015, this was the ultimate demand they could have raised. Now, Your Lordship,
You
kindly
paid this
see.
amount. You paid this amount.
Yes, yes. Next page, Your Lordship may see the next page itself, page 31, how this amount was arrived at. That has been, that calculation is there in next page. 2011-12 and all those license fee has been mentioned in the first, second column.
It is with liquidated damages.
No, this is license fee.
You just
And then because it was
license
said
fee,
that
outstanding liquidated damages 12%.
because it was, they say that it was not paid, therefore this is the ultimate.
Liquidated damages, they
Yes,
have a
yes.
clause.
And then I'll come to that. Your Lordship, each year the license fee has been mentioned, and the difference between 2 years is exactly 7%. I'll come to that as to how this 7%, why this 7% is there. So exactly 7% difference each year of enhanced 7% was enhanced. Then the total amount was 1,32,640. Then Your Lordship may kindly come to the next page. This is the letter by which we paid this amount. Although this was paid under protest, the protest was that the payment made by us for 1 year, that was not taken into account. Then also we paid the entire amount of 1,32,640, the entire amount. Despite protest, the entire amount was paid.
So it is also in dispute.
No,
No dispute.
not in dispute.
No
Yes.
dispute so far as till this particular payment.
Yes,
is
yes,
concerned.
yes. Page 34 is the entire bank draft.
That's right.
1,32,640, the second bank draft. By this amount was paid. Then, because the entire amount was no more outstanding was there, on 19th of April 2016, now a lease, this license agreement was entered into, and the period Your Lordship would get in the same page, page 35, the second paragraph, 1/4/2015 to 31/3/2016. So, in April 2016, for the period 2015 to 2016, this was this license fee was executed, and Your Lordship would find at page 37, paragraph 8. This is important because subsequently this is also has been demanded that the licensee shall pay so and so, all those amounts. Last two lines may kindly be seen. 3 lines in fact. For rupees 1,32,640, and after payment of this amount, all the payment are done and nil outstanding till 2015-16 from 2011 to 2015-16. So till 2015-16 absolutely nothing was due to be paid by the HPCL petitioner to the railways. Now your Lordship may kindly see the demand, that is Annexure 5 at page 40.
Page 40.
Page 40. Before that we had requested that further demand note may be issued so that we can make payment. That is Annexure 4 at page 39, and then subsequent thereto.
From the period 2015 -2016, you must have paid your amount till 2020. What happened in between?
No, we
No
did not
payment.
pay. We did not pay because only upon demand note being issued by the railways, then only we can pay. And therefore, in 2018 itself, by Annexure 4, we requested for please issue us a demand note, because the demand note is issued after enhancement of 7% from the previous
This
year's
is license renewal. You are
Yes.
seeking renewal of license.
Yes.
This is for license renewal. But once during the license period, you were supposed to pay monthly amount also?
No, not
Only
monthly,
license, annual.
It is annual. It is annual.
You
So
pay
therefore,
annual.
Your Lordship,
Then,
second line of
17, 18.
Second line of Annexure 4 would, Your Lordship would find, you are requested to raise the demand note for license renewal acquired site for period so and so, so and so, so and so. So demand note has to be issued, and therefore we have requested demand. Then Your Lordship may see Annexure 5. This is the letter we are seeking quashing. And realization of outstanding license fee of rupees 2 crore 64 lakh 67,320 on account of using railway land measuring 8,000 square feet for HPCL pump at Dhanbad. And by reference above so and so, it is intimated to you to deposit the outstanding dues towards railway for using the land measuring up to 8,000 square feet. You have not deposited any amount after 2015-16. The outstanding dues towards the license fee of rupees 8,000 square feet of land up to 2019-20 is rupees 2 crore 64 lakh 67,320. You are requested to deposit the outstanding dues within 15 days of so and so, or else the railways will be forced to take action so and so. So this demand is suddenly raised of rupees 2 crore and 64 lakh 67,000. And then Your Lordship, what is the basis of this demand? Your Lordship would find it as page 41. Page 41. Details license fee calculation for Hindustan Petroleum Corporation Limited at Dhanbad station, at Station Road Dhanbad for railway station number so and so. And from 1953-54, and on the right side column, Your Lordship would find that continuously we have paid the license fee. From time to time we have continuously paid. And then on left side, the entire calculation has been made, and the total amount ultimately calculated comes to
The entire calculation is there. So how are you agreed by this?
yes, because still Your Lordship would find from the previous license which was annexure 3 till annexure 3, absolutely the license agreement itself mentions that absolutely no dues are there till that day. So how they could have claimed an amount or calculated any amount prior to 2015-16? They could not have, because they themselves in their annexure para 8 itself very categorically mentioned that this is the
See
one.
page 42, they have given you the calculation.
But Your Lordship, that is contrary to the license agreement. In license agreement itself, they mention that this is the outstanding, and till date all payment are done, and nil outstanding till 2015-16. So once they say, they could have, if they would have raised it at appropriate time, then the matter would have been different. Here they themselves very categorically, both parties say that absolutely no dues are there till 2015-16. So now after the license agreement has already, we have used the
There
land.
was no dues on account of license fee.
No.
What about this land value? There
Then
were two
also
partners.
it has to be in terms of the circular which they themselves use. They have what they, why I showed this particular, you may see annexure 1
You
at
see,
page
annexure
31.
1
Why
is
I showed
dealing
this point.
only with outstanding dues area measuring such and such.
Why
License fee.
why I was relying on page 31. Here your lordship would find that from 2011-12 the license fee was 18,433, 7%.
So
this is for
basically, it's
1
a
year.
matter of accounting.
Clear, absolutely clear accounting. Absolutely absurd calculation which they have raised. Now each
You
year,
come to page number 42.
page,
42.
yes,
You see the entry of 2015-16.
yes,
Serial number 63.
60.
3. You tell us, according to your calculation, you also have substantial accounts backed up.
Absolutely.
According to your calculation, what is from where they have committed wrong?
Absolutely, because till 2015-16,
You don't refer to that. You just tell us page number 42.
page 42,
Is
before
giving all
2000,
the balances.
yes, I'll show. From your lordship pointed out serial number 63, 2015-16,
Yes.
and before this itself, whatever amount has been mentioned, these dates
Which
would
is
not
the
have been.
figure? Which is the figure which have been mentioned and you have paid?
I have failed to
Out
pay.
of you have paid.
Yes.
You
Then
say
your
that
lordship
your
may-
dues were nil, right? As per this calculation, your dues does not appear to be nil.
This is absolutely a new calculation which has been made, which is contrary to the to page 31 itself. This is their own letter, page 30, 31, their own letter, where they themselves say that 18,433 was the actual license fee for that particular period, for 2011-12. Now, what they say for 2011-12, your lordship would find it from 2011-12, what they say now is 8,84,297. And before that also, all those amounts they have started calculation from 1953-54, when they have continuously taken payment of the license fee.
And
So
what
once
is the
the-
reason for fresh or when it rises to 5 lakhs, 5 crore?
5 crore again, because they that also your lordship may see. Again, page 44 is the next demand. Quit notice against
You
HPCL.
just this is your document, annexure 8 is your document, right? You just see page number 46,
Annexure
page 46.
46.
What is it that you have underlined over here? As you are aware that HPCL, read it please.
Yes. The second last paragraph.
What is it? Read it.
Yes.
What
As
is
you
it?
are aware that HPCL through its retail outlet at the concerned plot is supplying essential commodities being petroleum product Hence, closure of retail outlet will cause inconvenience to public at large. Kindly also consider that HPCL is willing to pay the outstanding license fee for the period 2015-16 if demand of Eastern so-and-so is reasonable and in accordance with so-and-so, and the same proportion it is increased. Now, in the next page, we have mentioned as to what would be the, now what calculation they should have done was page 31, your Lordship may kindly see. Each year only 7% was being increased, and this is 7% which they, according to their own circular, they can enhance in terms of the previous amount, previous year's license.
Where is the circular?
Yes. Your Lordship may kindly come to the counter affidavit in which they have themselves annexed the annexure B. Annexure C, it starts from page 29, the relevant circular, and the relevant portion it is at page 31, clause 7. As the notional land value will increase by 7% over the previous year's land value, as mentioned in para 5.2 above, the license fee will automatically go up by 7% over the previous year's fee from the 1st of April every year, suitable provisions of so-and-so. So, therefore, in terms of this clause 7 itself, your Lordship would find at page 31, where they have each year they have only enhanced 7% of the previous year's license fee. Exact 7% is
This is all regarding license fee. What about fixing of land valuation?
land value separately.
Para number 5. A market value would, however, be required.
This is for new license if they want to give.
Is there
not for-
is there any yearly enhancement of land value?
It is
Where
there.
is
It would only be
Where
for
is
the.
Because it says that as the notional value will increase by 7% over the previous year's land value. So
Yes.
there is a notional increase of 7%. So land value will increase by 7% and license fee will also increase by
Therefore,
7%.
correspondingly, the license fee would increase.
No. Land value will increase by 7%. They have two components. One
No,
is the
only one component. Because according
your
to this circular, I'll come to
Annexure 1 talks about both the things.
No.
Yes.
Only one thing.
No. Annexure 1, outstanding dues of area measuring 3,500 square feet.
Katrasgarh. That is for Katrasgarh. Therefore, I had
Then
pointed out
outstanding dues and area measuring
we are
8,000
only
square
concerned with area 8,000 square.
8,000 square feet. You see, you have outstanding dues of this. This is on account of license fee.
Only license fee.
No. 1,08478. Is it for license fee?
Yes.
Or
It is
it is-
license fee. It is license fee. The second column your Lordship was reading.
Yes, right and
It is license fee.
And then annual license fee 24,162.
Because according to them, because this is not paid, then they'll charge interest and other LD over that.
What was the license fee according
The
to
first-
Annexure 1? What was the license fee according to Annexure 1?
Your Lordship would get it from page 30 itself.
Yes, page 30.
Annual license fee for the year 2015-16 is 24,160.
That's right. And there is one more thing.
And this your Lordship
Number
would,
2, annual license fee for the year 15-16, 18,802.
where your Lordship is?
Just below serial number 2. You are not concerned with serial number 2.
No, that is separate land.
Okay.
We are only concerned with the first
one.
portion.
Then why the demand is of rupees 1,32,640 if the annual license
Because
fee
they
is-
say that previous year we are not paid, and therefore from 11
previous
to 15,
year the arrears are not showing on account of license fee.
it is on account of license.
How do you say? Outstanding
Yes, because
dues and area
outstanding.
measuring
I'll
certain-
show that.
If
also.
it was only
I'll-
for
I'll-
license fee,
I'll show that
where was
also.
the requirement of giving the area? How does that make it?
It mentions that outstanding dues and area measuring 8,000 from 2011 to 2015. and for till 2015, according to them, the total amount of rupees 1,08,478 is due. This is only on account of license fee. And this detailed calculation, is there in the next page. How this amount has been arrived at. The first line itself mentioned that in connection with the above, please arrange to deposit your license fee as stated. No land value has been mentioned. And the detailed calculation is there in the next page, page 31. Now for 2011-12, the license fee was 18,433 and liquidated damage, they say, then total amount of rupees so and so is there. Now then the amount was there, license fee was again enhanced to 19,723. This was again added, and then for each year it was ultimately for till 2015-16, each year 7% was increased, and till 2015-16 24,162 was there. So thereafter from 2016-17 onwards, only 7% annual increase could have been made. In terms of this amount, 24,162, and taking into a note the clause 7 of their own circular. Now what they are doing is that they are not taking this amount, rather they have now, before 2015-16, everything was paid. They could have, while signing this particular license annexure 3, they could have said that nothing has been paid or areas are still there existing. No mention of such areas in there is annexure 1 or annexure 3 also, which is license fee. In fact, the license fee itself mentions very clearly that till 2015-16, everything has been paid.
Where is your license document? Where is your license?
Annexure
It
3.
has been renewed from time to time, but where is your license?
Annexure 3, which I have just referred. From time to time it has been renewed also, and they have also accepted payment from time to time. Continuous payment have been made, that is reflected from annexure, their own annexure, which is there annexed to annexure 5. Their own detail, which also mentions that at the second last fourth column, second last column, where they have mentioned that these are the amounts which we have paid. Continuous payments have been paid. So they could have demanded that at that point of time itself. Now after 2015-16, when they themselves say that this is the last amount due.
Just see para number 8 of that license, page 37. It has two components, although it is blank, but it has two components. For land use, there is one amount, and the other is license shall further pay a sum of rupees thus in advance for the rent of the office accommodation. There are two components.
Two components, but your lordship, this is a standard format. They could have filled it up. And this is matching with the annexure 1. It is not that annexure 1 mentions something else. Annexure 1 only demands a license fee of 1,32,640.
You have heard it.
Yes.
Now, but then.
And last submission, that the land value would have been taken into account only for the purpose of freshly leasing out or license, not otherwise. Once the license was given, then it has to be only in terms of the clause 7 of.
So you want to say that for the purposes of
Now
license?
what they do is that after completion, and payment of all the dues, they only demand of total 1,32,640. They themselves say that this is the only amount due.
Where is the original license of 1953? You don't tell us that you have lost it. You can't say that. Because
Similarly,
that must have contained many clauses.
Similarly,
not
the
know.
railways also cannot say
Nobody
that
can
we have
say.
lost.
But it is not there before us. Certainly, we do not know what is the original terms and conditions of license. Renewal is a separate thing. What is the original terms and conditions of license are not there before us. We do not know whether there was any component regarding land. We do not know. Merely because there is a nil shown, you will have an advantage over that.
Because even prior to that also they have never ever raised any demand. So Your Lordship,
Because the
after
demands raised
Your
prior to
Lordship,
that are
after
not on
60
record.
years, after 60 years of license, can they, after using use the land 60 years and then they have continuously accepted license fee, then they can say that no, for 60 years.
Yes, what is your case? Why this kind of demands are being raised?
Lord, so far as that
You are
part is concerned.
accumulating the dues, not realizing it.
Yes, Lord. So can you see, my Lord, so far as the chart which is there, my Lord, in my counter of the chart which was shown as an
Same
example,
chart,
the
same chart.
clear part is in counter, my Lord. Annexure A, my Lord.
Yes.
My Lord, so far as the license fee is concerned, that was started in the year 1953-54.
Yes.
My Lord, it will be seen, my Lord, the balance has been shown with respect to the year 57-58, then 58, 59, 59, 60, 61. Matlab thereafter continuously, matlab so far as that part is concerned, the amount is there. The amount which is being paid. Now, this is the entire calculation which has been prepared, and on that basis, matlab so far as the amount of rupees 2 crores 64 lakhs.
You just see 1967-68 is again nil.
Yes,
defined,
ma'am.
right? There are other nil figures, that is at
Yes, 66,
1974-75.
Yes.
There are other nil
75,
82-83. You
Yes.
have nil figures.
Yes, ma'am.
Okay.
So far as those
Then
periods
you
in
have
which
nil
there was
figures
no
85-86.
balance
The
license fee.
dispute is thereafter.
Yes, ma'am. In fact, the correct dispute can be said to be 93, 94, or 90, 91.
No, it is 1986-87 onwards.
Yes, 86, 87. So far as that amount is concerned, that has been mentioned. So far as the balance license fee which is required to be paid, that has been calculated. Now, the issue involved in the present case will also be taken into consideration. Prior to that, the agreement or the license has not been brought on record. But from the perusal of the license, which was executed in the year 2015 for a 1 year, my lord, your lordship will see from there in itself, Annexure 3, my lord, page 35. Lordship, can you?
Yes. Page 35.
It is agreed that page 35 that the licensee shall have temporary use and occupation of the place of land described in the schedule hereto and shown in the plan number situated in so and so Dhanbad for the period extending from 1/4/2015 to 31/3/2016 for the purpose of laying, erecting, retaining petrol pump site station Dhanbad subject to such rules, regulations and bylaws as may from time to time made on by or on behalf of the administration or by or on behalf of the local authority in relation hereto and subject to the condition herein contained below. But this was the condition if at all there was policy decision with respect to the determination of license fee or the value of the land that was to be made applicable in terms of this license itself. Now your lordship will see that the licensee shall use the land referred herein solely on for the purpose of aforesaid for which license and not otherwise. We are not on that note. Para 4. That the licensee shall not transfer. The licensee shall not transfer or sublet the privileges mentioned in the clause hereof without obtaining the previous consent in writing of the divisional railway manager of the administration at Dhanbad. Lord, here I am just posing for a moment, Lord. So far as the fact of the case is concerned, Lord, the land has been obtained through license, Lord, from the railway by the petitioner, and thereafter it was given to the retail shop owner, retailers itself. Well, this fact was not known to the railway. We have come for the first time when a legal notice was given by the said retailer to the railway authority, my lord, which I will come later on, my lord. Therefore, I was referring, so far as the subletting is concerned, that has also been done by them. Now, from when they have allowed it to continue so far as the retailer is concerned, that has also not been brought on record, my lord. But from the said legal notice which has been given to us, my lord, that it appears, my lord, he is continuing and running the petrol pump. Now, you will also kindly come to the para 8. That the licensee shall pay as occupation money for the temporary use of the said plot of land a sum of so per year in advance prior to the commencement of the period to which the advance payment applies. Licensee shall further pay a sum of rupees so and so per mention oblique half year in advance for the rent of office accommodation provided. Last payment was made on 3/3/2016 by DD number so and so 1,32,000. After payment of this amount, all payments are done. Nil. Outstanding till 2015-16 from 2011-12. Well, this is the period, if at all it is being considered, then it can be said to be 2011-12 to 2015-16, my lord, so far as the amount of rupees 1,32,000 is concerned. My lord, we have given with respect to the balance amount which was required to be paid, but at that time, my lord, the correct amount has not been mentioned in the agreement. Therefore, it cannot be said that was the final amount which has been paid by them. My lord, this is my contention. Now, your lordship kindly come to my counter affidavit, my lord, in which we have brought the policy, my lord, annexure B, my lord. 10/1/2005. Well, page number probably should be
28.
Lordship. This is 10/1/2005, Lord. As it has been mentioned in the agreement, my lord, so far as the policy is concerned, that will be applied. Here you lordship will see. To the general managers, All India Railways and production units by the Government of India, Ministry of Railways. Policy on licensing of railway land for commercial plots, etc. Master Circular. Board's letter number so and so 29/8/95. Policy guidelines for commercial licensing of railway land last issued by Board's letter dated 29/8/1995. In supersession of the earlier policy directives have been amended from time to time. With a view to bring all such policy instructions under the one umbrella, it has been decided to issue a master circular combining all the instructions issued so far on the subject. Henceforth, railway should quote only the present letter for any further reference. The clause 2.2, leasing of land is not permitted except in cases where it is specifically approved by the railway board. Lands for the purpose of commercial use should be given on licensing basis only. In this connection, Board's letter 1982 may please be referred to. Temporary licensing of railway land to private individuals for the purposes of setting up shops, commercial office, vending stalls, clinics, etc. not connected with the railway working was stopped in terms of Board's letter dated 7/6/1984. This ban will continue in exceptional cases where such licensing may have to be done. With the prior approval of the board, license fee must be fixed by resorting to public auction, open tender for getting the maximum revenue. Licensing of ordinary commercial plots connected with the railway working is not connected to us. No? I am skipping 2.3 and 2.4. Then what?
Date of license fee.
Rate of license fee, my lord, the next page 3.1. License fee of plots will continue to be fixed as a percentage of the land value determined as per the procedure detailed in para 5 below. The percentage applicable with effect from 1/4/2004 to various types of plots will be as under. My lord, clause C would be, my lord, so far as the applicability in the present case would be. Ordinary commercial plots with temporary structures for stacking, storing, covered area, open area, 7.5%. Then, my lord, formation of standing committee, the periodical review, however, will be done by the DRM on the recommendation of the tribunal. The committee will review annually whether the traffic of no problem. Then the fixing of the land value, my lord, para 5. Next page, my lord. The market value would, however, be required to be taken to serve as a base value for working out rental fee payable. My lord, this shall be fixed on the basis of the land value of surrounding area as on 1/1/85.
They want to say that this is only for those when there is a fresh license.
No, my lord, your lordship has seen, my lord, so far as this policy is concerned, this was issued in the year 2005. The 2015-16, my lord, it has been said that so far as the policy is concerned, that will apply to them also. So far as that part is concerned. That was also a condition, so far as the license is concerned. Therefore, on the basis thereof, my lord, only the determination of the licensee and the, so far as the occupation is concerned, that is to be done. Therefore, my lord, the procedure which has been given in this policy, on the basis thereof.
You see, this is essentially a commercial suit, right? We are in business. Why should we interpret these clauses? Yes, Mr. Rahul. Go and file a commercial suit. Get the matter at hand. Why should we decide? Why should we go into accounting?
There's no question of, I'm just showing the arbitrary nature of the demand, absolute arbitrary. Your Lordship may see the annexure 5 which I was referring. There is a chart, and what they do is that they are
We are not
only,
going to decide your commercial.
Your Lordship,
Go and agitate your.
once they have already said that this is the total amount which is standing
Estoppel,
as
you
on.
want to plea estoppel? You want to.
Absolutely,
plea
absolutely. In 2015-16, they said that this is the total amount due, and now what they say
You will have many
that
points. You will have a point of limitation. You will have so many things.
But Your Lordship, since 53,
Why
once
this,
they
why
have,
this in bracket it was mentioned? 2011, 12,
11,
15,
11,
Why
12,
was it mentioned?
because that is the only amount due. Before that, every amount has been paid.
That cannot be inferred. Otherwise, that period would not have been
But
mentioned.
this is also a matter of interpretation, no? Why this? Why in bracket it has been mentioned?
And
Why?
this is
What was the purpose of mentioning?
this is fortified from Annexure 3 itself, where it says that till 2015-16, no further amount is due after 1,32,640.
Estoppel, we are not doing.
And this is the only 1,32,000 was the demand, and the amount of rupees 2 crore which they now
But we
claim.
are not going to
Your Lordship,
determine.
all
See,
those.
we will not enter into these calculations, nor we will enter into the interpretation of whatever is there. Your original license is not there before us. We do not know what was the terms and conditions of the original license. You are only referring to renewal.
Now, one thing,
That
last
is a basic document, isn't it?
last submission I'll be making. Your Lordship may kindly come to the chart itself, because that is the amount where they have justified as to how 2 crore and what was
Both of you are
claimed by
relying
them.
upon this.
Only on the their claim is only towards license fee. And in 2000, now 23-24, 2020-21, now they say that from 1953, these are the license fee which are due, and you have only paid a sum of rupees so and so, which were already paid by us. Those amounts were deducted, and now they are claiming the amount from 1953.
No, 1953 doesn't
They
have
are
any.
claiming,
No.
absolutely clear. Your Lordship may see
No,
the.
you see, you have
Therefore,
nil
I
balance
said-
also. You have nil balance also. You have
No,
nil.
Your Lordship may see that annexure. Therefore, I said.
You just see there are nil balances.
Therefore,
You
Your
have
Lordship
nil
may.
balance in the year 1986.
Yes, because they
87.
deduct the amount which I have already paid, and then they say that this is the balance license fee which is due, and all this due amount is from 1953-54. The first amount due they are showing in 56-57.
1986-87.
Serial 4, Your Lordship may see.
balance. You come to serial number 33.
30.
3.
This is the license fee which they say.
Balance nil.
Before that, I may be allowed to place the serial number 4 itself, I am sure.
No, why should
From-
we go behind that? When
Be-
the balance is nil
Because
in
all
86,
these
87.
are ultimately the balance license fee the total of balance license fee has come to 2 crore 64 lakh. So it starts from serial number 4 itself, 1956-57. In 1956-57, this amount of balance they show, and
You
then
see, the
all these
total is the
balances have been
balance.
shown.
The balance is in connection with the balance license fee, no?
Yes, yes.
Column.
Balance
They have
license.
shown.
Every year they say that this is the balance which
Okay,
is
and
left
they add
out.
up to that.
Yes, and after deducting the amount which we have already paid, they themselves say that we have continuously paid, and therefore this is the balance amount which is remaining, which is there in the balance license fee column, and then they ultimately arrive at this figure. So before this 2011-12 also, they continuously say that all these 1 lakh so and so, 4 lakh so and so, all these amounts are unpaid. When they themselves say that till 2015-16 only this amount is due, which
You
is
just see 1950, 65, 66.
65,
66.
and your lordship would also
65,
find that
66,
absolutely
66
land
on
value
right
column
hand
is
side.
absolutely zero.
No. You see, 65, 66, serial number 13, right hand side. 1 kattha is equal to this much decimal. Land rate is this much. Why
This
are
was-
they referring to land rate?
This was for calculation of license fee. They themselves say that this was the basis taken for calculation of license fee.
So
But
the
now
net 7% increase is not correct.
They-
7%.
7% that circular has come in 2005, and in that circular itself, and my license is from 1953.
It requires lot of determination.
But at least this demand is absurd in terms of annexure 1 itself, 1 and 3.
You are in possession.
Yes, I am in possession, but
You are in possession. If you want to challenge the demand, if you want to challenge the accounting, you go and challenge it. Why should we decide a commercial suit here? It is essentially a
Your
commercial
Lordship,
suit.
I'm just
between
trying
two
to
parties.
show, I'm just trying to impress
You
that
see, you are
the
trying to
demand
show,
which has
just a
been
moment,
raised.
just a moment. You are trying to show that there is an arbitrariness.
No, arbitrariness in the nature that
And then apart from that, it is not your case that the demand should be nil.
it is there, what I am
It is
trying
not
to
your
show.
case either
Your
that
Lordship,
the demand should be nil.
from their own document, I am just trying to show that from before even 2011-12 also, and from 1953 till 11-12, they are raising the demand. Although I have already, they themselves say
You
that I
have
have paid,
that,
they could not have raised this demand. Even if the calculation is taken to be incorrect, then there absolutely no
You
amount
have
they could have
that
paid.
forum for resolution of dispute between two government sectors. There is
I had also heard earlier, but
what
I'm not
heard.
sure.
It is very much there.
I'm not sure.
It is very much there. There is a forum
I had
where
heard.
two government companies, if they are fighting, instead of going into litigation, that forum is
I'll
there to
verify and update
resolve
you
the
on it.
dispute between the
You know,
parties.
then
Yes, it was.
day after tomorrow,
I had heard, but I'm not sure.
I gave the detail.
I am aware of that. You are not aware. You are not also not aware. But the income tax में इतना दिन काम किया आपको पता नहीं. There is a forum, and that forum is known as dispute resolution. It is a mechanism framed by Government of India so that two government sectors, they do not fight with each other. There is a mechanism for resolution of dispute between the two. है ना? पूछिए उनको पता हो.
There is one memorandum which says settlement of disputes between central public sector enterprises inter se.
Yes.
will evaluate other things.
I know it is there.
But मतलब this is
लड़ाई क्या होता था बताते हैं, जब यहाँ डिस्प्यूट के लिए जाता था उसके बाद क्लेम टाइम बाद होता था. So the problem was whether the claim has become time barred, because under the statute if it goes for mediation then the period is excluded, but that period is not excluded for litigation otherwise. But there is a forum to resolve this dispute. There is a forum for this.
At least 10 years back I had heard there is a forum, but I was
10
not
years
sure
back.
whether it was
100%
active.
it is
This
there.
later has been issued by the Ministry of Law and Justice on 31st March 2020.
What is it?
This is settlement of disputes other than taxation between government ministries, department, inter se, and between government ministries, department, and other ministries, department, organizations, administrative mechanism for resolution of disputes.
Yes, I know. I am aware of this.
This is
I am aware. उसको भाई जरा लेकर आइए, उसी के पास भेजेंगे.
हम निकाल.
क्योंकि it
Day
is
after
essentially
tomorrow.
matter.
Yes,
There
yes,
is no
yeah.
reason that Ministry of Railway will be in loggerheads with HPCL. It's a government sector.
It's also clear.
फिर झूठ मूठ का लड़ रहे हैं 1 घंटा यहाँ से. It's not in public interest to waste so much of time and energy in court proceedings for two public sector. एक और केस में हम लोग भेजे थे, NBCC का लड़ाई चल रहा है. NBCC National Building. Yes, I was there.
There is another one on 14 December 22 issued by the Ministry of Finance. This is with respect to settlement of commercial disputes between central public sector enterprises, inter se, and central public sector enterprises and government departments.
हम बता रहे हैं ना. These are circulars. पता
These
कर
two
लीजिए
circulars.
किसके पास भेज देंगे, टाइम फ्रेंडली कर देंगे. ठीक है. WPC number 655 of 2021 heard the learned counsel for the parties at length. During the course of argument, it transpired that the petitioner HPCL is fighting with railways, and both are public sector undertaking.
The union, this is a part of the Union of India.
Public sector undertaking.
The first one,
The
petitioner
petitioner is a public sector undertaking, and so far as the respondent is
is a
concerned,
part and
is a part and parcel of Union of India. Essentially they are fighting for the dues in connection with the demand which has been raised by the respondents upon the petitioner
relating to license fee of the
relating to license fee / land value. The parties are directed to explore as to whether the matter can be referred to the body created for the purposes of resolution of dispute between government, public sector undertaking
and the ministries
and the ministry
the government organization.
and government organizations, so that the issue is resolved for all times to come. Day after tomorrow. Supplementary. 2:15 बजे. 2:15.
Any time,
सवा दो.